next matter to come before the court is Beanita Pettry versus Ohio Department of Jobs and Family Services et al. I note that we are running a little ahead of schedule. Is there any objection to starting this early? Do we have all the necessary counsel and any guests?
We're okay. Yes, Judge.
No objection? Thank you. I also note that there has been a motion for, I don't want to say law clerk, but a student assistant.
Legal intern?
Legal intern, thank you. I'm sorry I couldn't find those words. To argue the case that has been granted in this case. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve any time for rebuttal, please let me know when you get started because I'm keeping the clock this morning and let you know about the passage of time. Also, please don't use the names of any victims or minors as we are recording this oral argument and it will be posted on the court's YouTube channel. The judges have read the briefs and we are ready to proceed when you are.
Good morning, may it please the court. My name is Lori Hartman. I'm a legal intern with the Civil Litigation Clinic at Cleveland State University College of Law, and the clinic represents the appellant in this matter, Ms. Beanita Pettry. I'd like to reserve 3 minutes for rebuttal, please. This is an appeal from the denial of unemployment benefits to our client, Ms. Pettry. A denial for benefits requires a determination that the employee was terminated for just cause, according to the revised code 4141.29 D2A. The UCRC Unemployment Compensation Review Commission found just cause. However, fault is a necessary component of a just cause determination per Zangus, Placus, and Manos, and the record here would not support a finding of fault sufficient for a just cause determination. Therefore, I ask this honorable court to reverse. In reviewing denial of unemployment compensation claims, the sole focus is the UCRC decision per Lorain County auditors and the appellee's brief at page 6. And the appellate court must reverse if it finds that the UCRC decision was unlawful, unreasonable, or against the manifest weight of the evidence. So as background here, our client, Ms. Pettry, was an employee with Rite Aid in a retail location for 2.5 years. She had no previous discipline, no prior outages or action taken against her. Ms. Pettry fell victim to a very sophisticated scheme as is outlined in both of the briefs and the transcripts. There was immense knowledge of internal procedures, personnel, and processes. The purpose of the Unemployment Compensation Act is to protect those employees who, through no control of their own over the situation, are separated from employment, per Markovich. Here, based on the intense and immense amount of inside knowledge that the scammers had in this scheme, it would seem that it would be out of Ms. Pettry's control. So is Ms. Pettry at sufficient fault not to be terminated from employment, but to be terminated with just cause is required for a denial of unemployment benefits? A just cause discharge determination requires faults of the employee such that the employer demonstrates behavior that is an unreasonable disregard for their employer's best interest. And that's again from Markovich. So all of the available evidence that we have before us shows that Ms. Pettry acted reasonably. The hearing officer found in the UCRC decision that it was a reasonable belief that she held that she was on the phone with Brian Stimmel, who was the district loss prevention leader. So if she believes she's on the phone with an internal personnel from Rite Aid, whose job it is to prevent and stop scams, is it not reasonable that she would follow his instructions? And what he was indicating to her was the protocol at that point in time. Ms. Pettry acted believing that she was deactivating cards in the midst of an ongoing scam for her employer's benefit. Similarly, 5 other locations fell victim to the same scam. So, as she was trying to deactivate the cards, as she was working quickly within this 45-minute window, which is a real time limit that they had to deactivate cards, and through her subsequent actions. So once the scam was perpetrated and she got off the phone with who she believed was Rite Aid personnel, she called Brian Stemmel back and he was unavailable. She called her manager then, so she continued to act in her employer's best interest. Even days later, when the regional loss prevention manager, Kevin Brown, came into the store to take her statement, she complied fully. She states in the record that she gave all this information and all this detail to help Rite Aid in the future prevent a similar thing from happening. So there's a similar case, La Chapelle, which we've mentioned in our brief, which is a 6th district case, where an employee raised a concern that the CEO is improperly using funds, but she raised that concern to the wrong person in a technical violation of a policy. So the company let her go. And it found out after further investigation that it was unfounded. The CEO was not improperly using funds. However, the court, once it made it to the 6th district, reversed the lower decisions because they found that what she was doing was actually working with her employer's best interest in mind. So although she had technically violated a rule, she was working in her employer's best interest.
In this case, though, the employer lost money because isn't the policy that she not give those numbers over the phone and has to have a live person?
The policy is that she's not supposed to attempt to activate over the phone. She was attempting to deactivate over the phone. And she was not faced with a customer over the phone, so in her own statement, she says she's been in retail in a similar position since 2008. And she said, I know how to do this. When people call in, you hang up the phone. You don't have a customer in front of you. I understand that part of the policy. Did this apply in a situation where she thought she was reasonably speaking with an employee of Rite Aid who had been in the store the day before, who she personally knew? And does it apply when then, 45 minutes later or however many minutes later when the regional loss prevention leader calls back in and says the same thing, hey, we need to deactivate these cards, give me the numbers so we can do it. Was she unreasonable in complying then with Kevin Brown after the fact? So the policy at best is vague, and the training on the policy is at best ineffective. Instead of conceding the complete failure of the policy, Rite Aid chose to blame these managers at 6 different locations. The record provides no evidence of a policy or training on people impersonating to be Rite Aid personnel or pretending to be Rite Aid personnel. During the hearing, Mr. Brown, the loss prevention manager, said that in regards to this policy, Ms. Pettry would have been trained on the policy. So he didn't have personal knowledge that she had been trained. It would have been when she was hired, part of her orientation, 2.5 years prior to the incident. So in conclusion, I would just say that the evidence does not support a finding of just cause that Ms. Pettry acted with unreasonable disregard for her employer's best interest. The facts do support that this was a successful, sophisticated, unfortunate event, which the hearing officer also conceded in their reasoning. The record does support that 6 stores of Rite Aid fell victim to the scheme, all within this one regional loss prevention leaders district, and that Ms. Pettry had received no discipline prior, and ultimately Ms. Pettry acted reasonably with her employer's best interest at heart. So accordingly, we ask that you reverse.
Thank you, Council.
Good morning. Good morning, Brian Murphy. I'm Assistant Attorney General with the Ohio Attorney General's Office. Judge Council, good to see you again. To the other two judges, pleasure to appear before you for the first time. I represent the Director of the Ohio Department of Job and Family Services, an interested party in this matter, and an appellee. And the Director is asking that this court affirm the Review Commission's December 14th, 2021 decision because that decision was not unlawful, unreasonable, or against the manifest weight of the evidence. And that's this court's standard of review. It's a very limited standard of review, not an abuse of discretion, as with many other administrative appeals, and not de novo, as the Supreme Court has pointed out, where this court could make fact findings, reweigh evidence, reweigh witness credibility, which is really what Ms. Pettry is asking this court to do. The Review Commission's decision concluded that Rite Aid had just cause in connection with work to discharge Ms. Pettry, and consequently she wasn't eligible for unemployment compensation benefits. Essentially that there was a disqualifying separation, specifically because Ms. Pettry had violated a company policy regarding prepaid cards. That policy that she violated the policy by divulging account numbers and PINs for those prepaid cards over the phone. She thereby activated 7 cards, giving scammers access to more than $3,300 in prepaid card funds without spending a dollar to purchase them. The Director submits to this court that violation certainly constitutes just cause to terminate the employment relationship, essentially a justifiable reason for an ordinarily intelligent person to do that. So a justifiable reason for Rite Aid to terminate the relationship. The company policy at issue is to never attempt to activate a prepaid card or, and the important part in this case comes after the or, provide prepaid card account numbers or PINs if instructed to from an incoming telephone call. The Review Commission's decision was not against the manifest weight of the evidence. It wasn't unreasonable, given that Ms. Pettry did provide account numbers for the prepaid cards and PINs over the telephone. Admittedly, she didn't make a phone call, but that was prompted by an incoming call first. So it was an incoming call from a scammer that led her to make an outgoing call. It's really a distinction without a difference in this matter. Ms. Pettry's claim that there's no evidence in the record to support the hearing officer's ruling, the Review Commission's ruling, is simply meritless based on those grounds. And you can see the evidence of activation of cards. I mean, she literally did activate cards. That's what she did. She may not have believed she was, but interestingly, if you look at it from the point of the scammers, they believed she was activating cards. The 7 cards were loaded with more than $3,300, and Rite Aid couldn't stop those transactions. There were 7 receipts produced in the record, so those 7 receipts show that cards were activated. Ms. Pettry's subjective beliefs are really irrelevant to this matter. It's an objective assessment and analysis that the Review Commission engaged in and found that she had provided prepaid card account numbers and PINs and had activated cards for these scammers. And there's grounds in the record to support those findings. Specifically, most importantly, Ms. Pettry's own admissions. Ultimately, there's an argument about training here, which frankly I don't think really was even an issue before the review commission. Training really isn't an issue. Ms. Pettry knew about the policy, violated the policy, and that was to Rite Aid's detriment financially, which ultimately is Rite Aid's number one goal was to make money. $3,300 might not seem like a humongous amount to Rite Aid, a rather larger corporation. I don't know if it is or isn't, but it doesn't matter. It's several $1,000s worth of loss to Rite Aid. What Ms. Pettry is really asking the court to do in this situation is reweigh this evidence, reevaluate the evidence. But that's not what this court's here to do. This court's simply here to analyze, and evaluate whether the review commission had grounds to find just cause to terminate and discharge Ms. Pettry. A couple other points with regard to the argument that the review commission didn't make a fault finding and therefore the decision is unlawful. Legally, there's no requirement in the revised code or case law that says a hearing officer or the review commission needs to put the word fault into a decision. It's just not legally required, but factually, fault is whether there was whether Ms. Pettry unreasonably disregarded Rite Aid's best interest. And what this all comes back to is the policy, and the policy just said, don't do this. Don't give account numbers out over the phone. Don't give pins out over the phone with regard to these prepaid cards. If she had simply abided by the policy, there would not have been any reason to terminate her. She still, presume, I'm going on a limb here to say, she would have had a job the next day and into the years going forward if she just had abided by the policy. But the hearing officer, the review commission's decision had grounds at which you can find fault. The disregard of Rite Aid's best interest in violating the policy and causing the monetary loss. Finally, I think that the third argument that the review commission's decision basically wouldn't give rise to fault is a lot like the first argument, that there's not competent, credible evidence to find fault. It seems like it's one and the same. But I did want to point out that there's this argument about whether Ms. Pettry deliberately and willfully was trying to harm her employer. It's not really the standard. The case that Ms. Pettry cites, it's a 10th district case called Sindel out of in 1991, revolved around a factory assembly line, basically, and it looked like, from the facts, that the workers were given the final 5 minutes of their shift to leave to clean up their areas. Somehow that policy changed. It wasn't communicated to the employee, and the employee left 5 minutes early to do what he normally did in the past. And his ordinary actions were no longer allowed. He was terminated. And what the court said there was, look, that was a misunderstanding. Like that wasn't communicated to him, this new way of doing things. The new policy, the new procedures. That's not the case here. This procedure of don't give account numbers out over the phone on these prepaid cards, the pins for these prepaid cards over the phone. That wasn't anything new, and frankly, Ms. Pettry acknowledged that. What I think you can ultimately fall back on in this case is Ms. Pettry simply needed to adhere to the policy that Rite Aid had disseminated. She didn't, and it cost the company several $1,000s. If she had, she would have still had a job, and that's really the reason that she's not eligible for unemployment, is she still would have had a job had she done what the company asked her to do. If there are no other questions, the director asks that the board affirm the review commission's decision.
Seeing none, thank you.
Thank you.
So Your Honors, in response to some of those comments, first of all, we are not asking you to reweigh the evidence. We argue that all of the evidence is in the record and that the hearing officer and the UCRC needs to consider all of that, especially in a situation like this where the standard, as conceded by the Assistant Attorney General, is reasonableness. It's a reasonableness standard for fault, whether or not she acted reasonably. And again, back to the hearing officer's determination that it was reasonable for her to believe that she was on the phone with the district loss prevention manager, would it then not be reasonable for her to follow those instructions? So we spent a lot of time here listening about the policy, but there's also just the common sense reasoning of the situation. So the policy was never brought up to Ms. Pettry following the incident. The policy was not brought up to her when she made the statement. When she was fired and terminated and asked her manager why she was being terminated, her manager did not cite the policy. The manager did not know. It seems like the policy was the pretext for getting rid of these managers who all fell victim to this very sophisticated scheme. So whether it was reasonable for Ms. Pettry to know that it applied when she says in the record, did you know that this policy applied to this situation? And she says no. Obviously there was either insufficient training or the policy really was not intended to fit the circumstance. It's being retrofitted at this point to create a just cause termination. And in terms of the loss, again, we acknowledge that Rite Aid took a loss that day at all 6 stores and that loss is unfortunate. But also the managers at those stores who happened to be on call that day. Ms. Pettry was the most senior manager, that's why she took the phone call. That's why they asked for her in the store. Her manager was not there. So luck of the draw, she got the call. She was the person on the phone. She's the person who lost her job. She's the person who lost her income. And then after all of that is said and done, certainly Rite Aid can fire for any or no reason at all. But then she was denied unemployment benefits, which is why we're here today. Is that a reasonable thing to happen to a woman who's working through a global pandemic, showing up every day, has no disciplinary action on the record, and the purpose of the Compensation Act is to protect employees who through no fault of their own and through no control of their own fall victim to a circumstance out of their control. So again, we ask this court to reverse, to find, just like the hearing officer found that it was reasonable for her to believe she was talking to Brian Stimmel, to then continue that thread, and instead of leaping from it was a reasonable belief that she was on the phone with a manager, to then go to she violated a policy, to sort of think about that in the whole context, the totality of the circumstances before you. Thank you.
Thank you. Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision with the agreement of all parties in this appeal on the day it is issued by the clerk of courts, as well as posted on the Ohio Supreme Court website.